was first articulated in 1954 in Shirur Math. I will say Shirur Math. A seven-judge bench of this court considered a challenge to the Madras Hindu Religious and Charitable Endowments Act 1951, which empowered a statutory commissioner to frame and settle a scheme if they had reason to believe that the religious institution was mismanaging funds. The petitioner, the Mathadipati, superior of the Shirur Math monastery, claimed that the law interfered with his right to manage the religious affairs of the monastery and therefore violated 26B of the Constitution. B.K. Mukherjee, writing for the court, noted that Article 26B allowed a religious domination to manage its own affairs in matters of religion and framed a question on the ambit of matters of religion. The language undoubtedly suggests that there could be other affairs of religious domination or a section thereof which are not matters of religion and to which the guarantee given by the clause would not apply. The question is, where is the line to be drawn between what are matters of religion and what are not? The court cited with approval the judgment of the High Court of Australia in the Adelaide Company of Jaws Witness versus Commonwealth, which held that the Constitution protected not only liberty of opinion but also acts done in pursuance of religious belief as part of religion. The court noted the importance of both religious belief and the practice that stems from it and provided an expansive definition of religion. A religion undoubtedly has its basis in a system of beliefs or doctrines which are regarded by those who profess that religion as conducive to their spiritual well-being. But it would not be correct to say that religion is nothing else but a doctrine or a belief. The guarantee under our Constitution not only protects the freedom of religious opinion, but it also acts done in pursuance of a religion, and this is made clear by the use of the expression practice of religion. That is, practice of religion, acts done pursuant to a religion. That is how the lordships understand. Drawing a distinction between religious and secular practices, the court held what constitutes the essential part of a religion is primarily to be ascertained with reference to the doctrines of that religion itself. But this sentence, lordships may kindly see how Justice Chandrachud later on distinguishes. If the tenets of any religious sect of Hindus prescribe that offerings of food should be given to idol at particular hours of the day, all should be regarded as parts of religion, and the mere fact that they involve expenditure of money or employment of priests and servants or the use of marketable commodities would not make them secular activities partaking of a commercial or economic character. All of them are religious practices and should be regarded as matters of religion within the meaning of Article 26B. The court in Shirur Math case ruled that the freedom of religion guaranteed by the Constitution applied to freedom of both religious belief and practice. To distinguish between the religious and secular, the court looked to the religion itself and noted that the views of adherents were crucial to the analysis of what constituted essential aspects of religion. This approach was followed in Ratilal Pannachand Gandhi versus State of Bombay, where a constitution bench of this court considered the constitutionality of the Bombay Public Trust Act 1950. The act sought to regulate and make provisions for the administration of public and religious trusts in the state of Bombay. The petitioners challenged the validity of the act on the grounds that it interfered with their freedom of conscience, their right to freely profess, practice and propagate their religion, and their right to manage their religious affairs under Article 25 and 26 of the Constitution. B.K. Mukherjee, for speaking for a constitution bench of this court, expanded upon the meaning of scope of Article 25. Subject to the restrictions which this article imposes, every person has a fundamental right under our Constitution not merely to entertain such religious beliefs as may be approved of by his judgment or conscience, but to exhibit his belief and ideas in such overt acts as are enjoined or sanctioned by his religion, and further to propagate his religious views for the edification of others. Speaking with reference to Article 26, Mukherjee reiterated the broad view taken by this court in Shirur Math case that religious denominations had complete autonomy to decide what religious practices were essential for them. Religious practices or performance of acts in pursuance of religious beliefs are as much a part of religious religion as faith or belief in particular doctrines. No outside authority has any right to say that these are not essential parts of religion. And it is not open to a secular authority of the state to restrict or prohibit them in any manner they like under the guise of administering the trust estate. The court, however, recognized the limited role of the court in the determination of such a question. The distinction between matters of religion and those of secular administration of religious practices may at times appear to be a thin one. But in case of doubt, the court should take a common sense view and be actuated by consideration of practical necessity. Their lordships are quoting Ratilal Panachand Gandhi versus State of India. But kindly see now para 263 onwards. The late 1950s witnessed two cases that were crucial to the evolution of the essential practices doctrine. Now, my lord, there is a shift in the judgment of Sabrimala. First, after quoting Shirur Ratilal Gandhi, where they restrict that court has a limited role, only confine these things to the judgment of that religion. Now, kindly see, in the Venkataramana Devaru versus State of Mysore, a constitution bench of this court considered the constitutionality of the Madras Temple Entry Authorization Act 47, which sought to reform the practice of religious exclusion of Dalits from a denominational temple founded by the Gauda Saraswat Brahmins. This is the judgment I was citing earlier. The court accepted the claim that the temple was a denominational temple founded for the benefit of the Gauda Saraswats and proceeded to examine whether, exercising the right of religious denomination of Article 26b, they were entitled to exclude other communities from entering into it for worship on the ground that it is a matter of religion. Rather than allowing the religious domination complete autonomy in the matter of deciding as to what rites and ceremonies are essential, the court examined scripture and precedent to determine whether the exclusion of a person from entering into a temple for worship was a matter of religion under Hindu ceremonial law. Venkatramaya revived ancient literature, practice of Hindus, and the role of temples in that practice and concluded on behalf of the court. Thus, under the ceremonial law pertaining to temples who are entitled to enter them for worship and where they are entitled to stand and worship and how the worship is conducted are all matters of religion. This firmly established the court's role in determining what constituted essential religious practice. However, the matter did not end here. The Gauda Saraswats claimed their right to manage their own religious affairs under Article 26b, whereas the state claimed that it had a constitutional mandate to throw open Hindu temples to all classes and sections of Hindus under Article 25(2)b. Noting that the two are apparently in conflict, the court considered whether the right of a religious domination to manage its own affairs in matters of religion guaranteed under Article 26b was subject and could be controlled by a law protected by Article 25(2)b, throwing open a Hindu public temple to all classes and sections of Hindus. But may I request Lordships, I don't think, I want to draw Lordships' attention to para 266, which according to me, 266 and 267, which is what we want to emphasize on. 266, what may I? This case marked, what may I, do I get Lordships' attention to 266?
Yes.
This is how this case marked a nuance of the essential practices doctrine laid down in Shirur Mat, where a denomination was granted complete autonomy to determine which practices it considered to be essential. In Shirur Mat, the autonomy to decide what is essential to religion was coupled with the definition of religion itself, which was to comprehend belief and practice. In Devaru, that is Venkataramana Devaru, the court laid down a crucial precedent in carving out its role, that is court's role, in examining the essentiality of such practice, while the court would take into consideration the views of a religious community in determining whether a practice qualified as essential, that would not be determinative. But this is so critical not for the entire discourse case before your Lordship. The earlier shift of focus is it is not necessary that whatever that religious denomination says that may be considered, but the court's role becomes very, very critical. And 267, what currently see, the way His Lordship has evolved the principle. Prior to Devaru, this court used the word essential to distinguish between religious and secular practices in order to circumscribe the extent of state intervention in religious matters. The shift in judicial approach, but kindly look at this sentence, what? The shift in judicial approach took place when essentially religious as distinct from the secular became conflated with essential to religion. The court's inquiry into essentiality of the practice in question represented a shift in the test, which now enjoined upon the court the duty to decide which religious practices would be afforded constitutional protection based on the determination of what constitutes an essential religious practice. But if Lordship permit me to say that whenever the history of the Supreme Court will be written, according to this paragraph 267, will have its prominence in golden letters for this reason. But the way His Lordship has evolved the principle, the Supreme Court, where they say, earlier the shift was what is essentially religious, to distinguish between a secular practice and a religious practice. You apply the tests to see if it is essentially religious, it gets the protection of Article 25. The shift, he says, post Venkatramana, there were a number of judgments. It is not just that. Even if it is essentially religious, you have to establish that it is essential to religion. That is the distinction. If they show before your Lordships wearing of hijab is essential to Islamic law, but they pass through the test, then of course public order, they are stopped there. But if it is not shown that it is not essential to religion, the matter stops there, the inquiry stops. And this is how their Lordships have, according to me, evolved this principle. Lord's para Home Lords in 1962, Ajmer case, their Lordships used the word essential religious practice. Shurur Mat case also said essential religious practice. They said the test was done in order to distinguish between a secular practice and a religious practice. If it is essentially religious practice, then you get the protection of 25. And of course, Avadhuta test, that these tests is emphasized here, 267. 268, but I do not want to read it in this context because there it is a Hanif Qureshi. I want to read it later. Cow slaughter, where they said sacrifice is considered part of essential religious practice. But how their Lordships have dealt with it, I want to read Qureshi's judgment separately itself. Because in this context of ERPs, 270 may be relevant. Yes. Their Lordships, Court Justice Gajendra Kadkar would say, our note of caution has been added. Same thing, I have read it before your Lordships. Dargah's case, Ajmer Dargah's case. $270, that's one. 270. But kindly in 270, after quoting Gajendra Gadkar and Dargah Committee's case, which I have read before, that is Ajmer case, kindly see the analysis of the Supreme Court of Dargah case, not in that paragraph itself, starting from the sentence, this statement pushed the essential religious practice doctrine in a new direction. The court distinguished for the first time between superstitious beliefs and a religious practice, apart from engaging in a judicial inquiry to determine that the practice claimed to be essential was in fact grounded in religious scriptures, beliefs, and tenets. The court would carefully scrutinize that the practice claiming constitutional protection does not claim superstition as its base. This was considered a necessary safeguard to ensure that superstitious beliefs would not be afforded constitutional protection in the garb of an essential religious practice. The court also emphasized that purely secular matters close to religious form do not enjoy protection as an essential part of religion. This is more, they have quoted, analyzed the Dargah case. Then Lord, the next case is that Bohra community excommunication case, which the petitioner counsel relied upon.
Which they have struck down that particular act.
The act, there, Section 4 barred them from excommunication. They said part of it, but kindly see what Justice Chandrachud says in that para 272, about this Bohra community case, last sentence, the decision in Saifuddin, same, is presently pending consideration for all larger. $272 last, Saifuddin case. This Saifuddin case, but the petitioners were advanced, had relied upon that. $285. But at paragraph 273 more, again Dargah committee is referred to. 279 Adityanath versus Travancore, there was some board, same principle. What I want to read is para 280. The Avadhuta test has been explained. 280. Another market case.
Tandava dance matter.
Tandava dance, yes. Where they claim that it is part fundamental character, which was negative. The question of the essential religious nature of the Tandava dance was considered again in 2004 in Commissioner of Police versus Acharya Jagadishwarananda Avadhuta. After Avadhuta 1, the religious book of the Ananda Margis, Karya Karya, was revised to prescribe Ananda Tandava as an essential religious practice. Laying emphasis on the essential nature of the practice, claimed the majority in a 2-1 split verdict held that practice must be of such a nature that its absence would result in fundamental change in the character of that religion. And again, para 9 is good. I do not want to read that. But kindly see analysis of Justice Chandrachud of this paragraph. Essential part of a religion means the core beliefs, so and so on. Next sentence. Essentiality test came to be linked to the fundamental character of the religion. If the abrogation of a practice does not change the fundamental nature of the religion, the practice itself is not essential. Rejecting the claim of Ananda Margis, the majority held that Ananda Margi order was in existence even without the practice of the Tandava dance, and such practice would not constitute the core of the religion. Further, religious groups could not be permitted to alter the religious doctrine to recognize certain religious practice in order to afford them constitutional protection. Notes at the paragraph, but I will only reading notes. I do not want to take lots.
Yes.
Yes, 200 and notes 80 after Ananda Margam, 282 relates to Shaira Banam, triple talaq, considered as part of religion rejected by the Supreme Court. Chief Justice Kehar dissenting. 282, 283, 284 is on Shaira onwards. I will read Shaira one independently, therefore I do not want lordships to. Can I read 284? Same thing, Shaira one was. But what is important is 285. Can I? Conclusion of the Honorable Supreme Court on these things. In its jurisprudence on religious freedom, this court has evolved. This is the summing up of the entire case law. This is the last of the decisions. So this can be taken as the law of the land as it stands today. In its jurisprudence on religious freedom, the court has evolved a body of principles which define the freedom of religion under Article 25 and 26 to practices essential to the religion. The Constitution has been held to protect not only freedom of religious beliefs, but acts done in pursuance of those beliefs. While the views of religious denominations are to be taken into consideration in determining whether a practice is essential, those views are not determinative of its essentiality. Number one, the court, this is sentence is also, the court has assumed a central role in determining what is or is not essential to religious belief. Intrinsic to the role which the court has carved out, it has sought to distinguish between what is religious and what is a secular practice. Even if it is associated with a religious activity, going further, the court has inquired into whether a practice is essential to religion. Essentiality of the practicehood, as the court has held, depends on whether the fundamental character of a religion would be altered if it were not observed. Above all, there is an emphasis on constitutional legitimacy, which underscores the need to preserve the basic constitutional values associated with the dignity of the individual. The ephemeral distinction between religion and superstition becomes more coherent in terms of the need to preserve the fundamental constitutional values associated with human liberty. In determining the essentiality of a practice, it is crucial to consider whether the practice is prescribed to be of an obligatory nature within that religion. But this is also very important. If a practice is optional, it has been held that it cannot be said to be essential to religion. A practice claimed to be essential must be such that the nature of the religion would be altered in the absence of that practice. If there is a fundamental change in the character of the religion, only then can a practice be claimed to be essential part of that religion. But from a reading of these things, I will not carve out 4 or 5 principles to be applied for the present case. Number one, the practice should be fundamental to that religion. Number two, if that practice is not observed or discontinued or not followed, it would result in change of the religion itself. Second test. The third test, very important according to me, is this practice must precede the birth of the religion itself, I am very carefully stating this word because of the sentence. The foundation of the religion must be based on that. That is how Lord, their lordships evolve the principle. It is not that the practice should evolve after the religion comes. Therefore, they say nobody can come and say which practice started from a particular day. That would not form essential part of the religion. Either the practice must precede or must simultaneously be there along with the birth of the religion itself. It must be so much coextensive with that religion. This is not this submission of mine, of course, not Lordships may test me, but it is based on the context of the word core belief. The they use the word cornerstone of the religion must be there. The cornerstone, what as I have understood, is the foundation stone.
It must be part of the cornerstone of that religion.
Of the religion. And the last one, what very interestingly is binding nature of the religion. If it is optional, then it is not essential. If wearing of something is optional, if somebody doesn't wear it and it's still permitted, then it is optional. It is not binding. It must be so compelling, that if you disobey, you cease to be part of that religion. These words, according to me, are the principles which can be called out.
Only 4 you have noted.
I have said essentiality, fundamental in nature. If not, second one, if not followed, the religion will change. Third one, words, it is not every activity associated with religion which can be characterized as religion, which includes dress and food. Lordships may kindly Dikshital food. Fifth one, words, is it should precede or be coextensive with that religion. Sixth words is binding nature of that. Now, Lords, with all humility, I want to submit before your Lordships. When they argued, Lords, before your Lordships on this question of essentiality test, not only for them, for us also, the opening should have been paragraph 285 of Lord's Shabarimala case, which is the foundation of the entire case between our petitioners and the respondent. Is that what is the foundation? Unless this is delineated, the question of declaring Lords any religious practice as an essential in this practice does not arise. Now, Lords, with this background, Lordships may examine the claim of the petitioners. But I will caution myself with this sentence. But this is not a case where Lords, few followers, let us say, of Ananda Margis came before the court and asked for essential practice, a substance, or Shabarimala devotees. This is a case, Lords, where it is not petitioners alone who have come before a Lord. They are seeking for declaration of a particular dress format to become part of religious sanction so as to bind every woman who follows Islamic religion. That is the seriousness of the claim. Every woman who follows Islamic faith is required to wear the hijab as per the religious sanction is a claim made by them by way of a relief. But kindly see the pleadings which have been placed before your Lordship in this background. But I wanted to open the submission by saying, if somebody has come before the court, in this case, particularly of such, the burden is entirely upon them. The burden rests upon them with these principles which the Honorable Supreme Court has evolved to show. Yes, this particular practice is fundamentally different. This practice, if not followed, will result in change of the character of the religion itself. If this practice preceded the birth of religion itself, this practice is binding in nature. If you do not follow, so you cease to belong to that religion. But kindly see the pleadings in the petition. There are a number of petitions. I do not want Lordships to shift the papers. Therefore, we have made the relevant pleadings relating declaration by way of a charge. So there are about 8 written petitions, and we have been very careful to go through every line of the pleadings, but to see what is the basis to ask for hijab to be a part of essential religious practice. Kindly see 2146/2022. What is the averment? Forget evidence. Forget the evidence. Para 22. Wearing headscarf by young girls is part and parcel of that cultural and religious practice. This is the only sentence we got to get it. WP 2880 of 22 para 4. Petitioner here conscientiously choose to follow the tenets of Islam, one of which is to observe hijab headscarf. Not only is it a part of their essential religious identity, but denuding them for pursuing their education unless they give up on it also an affront to their right to living with dignity protected under Article 21 of the Constitution. 24. Petitioner's practice of wearing hijab, which according to us is an essential part of religious practice, in no way interferes with the imparting of education. Para 26, injunction to wear a headscarf or hijab is an essential feature of Islamic practice, being ordained by the Quran itself. Para 28, they being followers of the Islamic faith since birth and is practicing an essential religious practice of wearing hijab headscarf. Para 36, petitioners believe that it is an essential part of their faith and conscience that they must wear hijab. Para 41 verses of Holy Quran and the narration of hadiths contain the essential religious practice to be followed by persons of Islamic faith. Then writ petition 2347 of 22. Religious practice of wearing the hijab is neither entangled in public law, nor is there any conflict between petitioner's right to religious freedom. Para 11. Thus, by keeping a check on such unfettered action on the state to deny the petitioner are guaranteed right to education merely on the ground of wearing the hijab, which is essential religious practice, would amount to reducing the rule of law. Para 16, the discussion in the aforesaid case would show that covering the head and wearing a long sleeves dress for women have been treated as an essential part of Islamic religion. In writ PIL, which has been filed, there is in the 3424 of 2022, no averments in the petition that wearing of hijab forms part of essential religion. There is no averment. In PIL WP 3821 of 2022, no averments. In WP 3853 of 2022, only one sentence. It is religious practice. In WP 3044 of 2020, covering the head and wearing a long sleeve dress. In WP so and so, 3038 of 2022, it's just saying essential. But now, Lords, I am nobody to criticize, I am nobody to say anything, but I can only say with a lot of responsibility. In a case of such kind, where you not only want to bind yourself, the petitioners, you want to bind everybody like this, and which gives rise to various sentiments, divisions, etc. You ought to have shown more circumspection and discretion in seeking declaration, particularly before a constitutional court. Law is something there, law is there for us, all of us. But foundation pleadings, so that it would have assisted a lot, it would have helped us in traversing or anything. But this material, but this test I only want, I took Lordship's valuable time to read this only to tell this, that if Lordships want to apply this test, what is the material, what is that material Lordships have to apply? That sentences, averments made by petitioners without even absolutely no material whatsoever. Therefore, what my submission is this, before I have something else to say, that the petitioners have not placed any material whatsoever, what's mechanism. Not sufficient material, but I'll say no material whatsoever. It is a zero material which has been placed. to substantiate their claim for a declaration that wearing of hijab forms part of a fundamental right to, that is to say, essential religious practice. They have quoted Quran. I will come to that. I have to say that. The Constitutional Court, which has been called upon to decide this issue, must examine this material with reference to the law which has been laid down very clearly as to how it should be declared as an essential religious practice. If Lordships venture to declare that, then Lords, and we're trying to apply those tests, Lordships will not find if 1 plus, if they want it to be declared as 2, it is 1 plus 0, it will not deal with anything else. The result will be 1 only, it can't be 2 for me. Now, what for the Quran they have quoted. Quran they have quoted. I will deal with that one and I will show before you. Now, but my responsibility, I thought, doesn't end there. Because it is not the petitioners alone before here. There are several men belonging to Islamic faith, but we are responsible equally as much as they are to assist your lordships and show whether it actually forms essential religious practice or not. Our examination source, independent of that, because they have failed to place material, but according to me, our role does not end. We will make an endeavor and show before your lordship. It does not. If it does so, I will concede before your lordship, whatever material we have. But an examination made by us independent, it does not. So that I will show. But before that, what I want to place before your lordships issues relating to what happened in earlier situations. Whenever different faiths, apart from the Anand Margi's exception, whenever reliance was placed on Quran for the purposes of declaration of certain practices, essential religious practices, in at least 4 instances, the Supreme Court negatived it. How they negatived it, I'll place it. These 4 instances are like this. Number 1, in Qureshi's case, first time in 1959, I will show before that, they quoted Quran to say that sacrifice of an animal forms part of Islamic verse and therefore must be considered as an essential religious practice. But their lordships not held, I will show that there is something like this. There is no sufficient material based to support for such a declaration. It was negative. Secondly, they said that what is not obligatory, what is optional, does not constitute essential religious practice. Second was what when Dr. Ismail Javed's case, lordships have said. I will take note. I'll just sum up. In Javed's case, they said that Islam protects plurality of knowledge. So any legislation which hits that belief should be declared as unconstitutional. Supreme Court said no, it comes in. Ismail Farouqi, Babri Masjid demolition case, was the case notes where the mosque was demolished, the government acquired the entire area by special legislation. Apart from other grounds, one of the grounds which they raised was it forms fundamental principle of Islam to pray in mosque. The acquisition of mosque takes away this essential principle itself. Essential practice of praying in a mosque, that was negative. I'll show how their lordships construed the problem. Maharashtra was not Islamic. But then what's Shairavan, of course. Where apart from others, there is a Mr. Kahmat said that no, they never considered Quran. No, I'll show you. They assume it is part of Quran. In fact, they assume it as part of Quran and say that yet so we cannot declare it as part of essential practice. We cannot declare it as an essential practice of Islam. These are the 4 judgments which would show. But 5th one, interestingly, I was associated, so I must say that's something which arose in Karnataka High Court, where there is a very popular hotel in Bangalore known as ITC Windsor Manor, still there. There, the land belonged to the Waqf Board, and it was leased out in favor of a particular company. The lease was challenged, but on the ground, one of the grounds was, apart from other things, of that the hotel would serve wine and pork, which is considered as haram in Islam. Therefore, the lease itself must be negative. In a reported judgment of the year 1981, Justice K. Swami, as he then was, said no, it can't be considered. These are all instances, of course, on different aspects the matter is still pending, but these were words on an examination, Lordship will say. It's not for the first time that a challenge is made before the court that something should be considered essential. In fact, a number of other instances. I only
Case which G. Ramaswamy.
Yes, England. Yes, absolutely. He went to Oxford University. The Honorable Chief Justice G. Ramaswamy is appearing for
To London to study Islam.
He went to Oxford University to study the concept of Quran to understand whether wine and pork, and of course, by his own inevitable style, he made an analysis saying that no, it does not suit. Finally, it was argued by pleas in the final. That's how this law I will be in a position to show it. So this is not something which has come up for the first time. If Lordships going back to the government order, if Lordships settles this position of law, that's one way or other. If it is held that hijab forms part of essential religious practice and passes those 4 tests, and schools cannot prevent it, and our government order automatically will not happen. If Lordships hold other way, then other considerations will come, which I will submit. Yes. The 2 other aspects I must mention. Mr. Tahir.
Yes.
Lordship said. Mr. Tahir Mohammed Tahir Lords had made a grievance before your Lordship about some amount of excessive practice by authorities, and he gave a letter to me this morning at 10:30 addressing the grievance. But I have already communicated to the Chief Secretary by way of a letter, and I've asked him to convene a meeting of all concerned, if possible today or first thing in the morning, to address all the grievances. How they would resolve it, I will communicate it to him. But rest assured, I have orally spoken to the Principal Secretary to Education Department and others. They have assured that nothing of this sort will be repeated. But whatever action taken by all the officials under the chairmanship of Chief Secretary could be reported to Lordship as well as to my management. Let him be rest assured. As to nothing untoward would happen.
My Lord, I may be given a chance, my Lord, because I would like to reply. Your Lordship, I am addressed insofar as the Islamic jurisprudence is concerned. And the judgments you cite, your Lordship, give me time first. I shall be grateful for that. Because there are very important issues, my Lord, which have been raised. So far as, my Lord, essential practice, religious practice, I can give the reply to my friend, citing, my Lord, the Quran verses to your Lordship, and making the position to clear, my Lord, how it is essential, my Lord, religious practice. Because we are deriving it from the Quran. Verses as they are give time first. Otherwise, it will result in travesty of justice, my Lord. Because doctrine, jurisprudence of Islamic law is very essential.
Mr. Dhar, in which case you are appearing?
My Lord, I am appearing in. That's why I am giving your Lordship's trouble, because certain points are very important so far as 3:9:23.
This is not a public platform where anybody can stand up and start speaking.
No, my Lord, I am there.
We are in the mid of the proceedings of a particular case.
My Lord,
Just
that's correct.
Union Advocate General is addressing the court. How you are interfering in between?
No, my Lord, I am just making a submission that I may be heard in 3:9:23
Don't
matters.
make
Because
submission. No, there is no time. There is no time to make any submission.
Lordship, one submission I want to make. In the connected matter, I filed a memo. They said that we also lodged a complaint to the Child Rights Commission. What they are saying is that they will be asked to remove and in front of the teachers, male teachers. So we are given a complaint. Some clarification has been issued today. It seems that learned advocate general can look into it. The copy is also served on them. Because right in front of some people, they are asked to remove the hijab as well as sometimes if they wear the burqa. Some place, separate place, if it is given and then not at the entrance of the gate. This is what we made a request to the Child Rights Commission also. So today they clarified, even from the TV channel also, how they are going inside. The TV channel are going inside and focusing on these things. It is really abuse of child rights.
You go and argue before the TV channel only.
That's why. That's why. Today, no, they have given a clarification. The Child Rights Commission chairman has given a clarification today. It has come in paper today. So my Advocate General look into this because it's clearly a violation of the child rights. So maybe they would have gone wearing hijab and whatever it is there. It cannot be in the open place. In
But
one other case should not be done.
One other aspect,
And teachers have been asked to remove the hijab.
Said that.
whatever is there, we take care. Rest assured. It can't be, but I am, nobody not be there, but we will definitely look.
I am not there, I am just
We
being
are sensitive to it, but we are not, the government which is very sensitive. But that the government order of 2014 Lordships wanted to.
Circular.
That it has received the approval of the minister. But I am placing that file before you. So it has received the approval of the minister. We'll place the-
If you say that, we believe it.
No, yes, I can also place the photocopy of that along with the memo. We have it. We place it before the registrar.
It has the approval of the government, then all
Yes,
that.
it has. I have the original report.
We are not disputing the government bringing the circular. Whether the circular is a law is an issue. That's what.
You will get your chance.
Yes. In a different context, Lordship.
All right, brother. So now we have come to that end of that, your second point of argument.
Yes, but it is not an essential religious practice. The second limb that has to be substantiated. The burden has not been discharged is what we have submitted. But an independent reading of Quran words would also show that I will be in a position to show.
We'll continue tomorrow,
Tomorrow, right now.
1:30. The arguments.
One submission, this court also passed the order in 3853. I am also producing the memorandum of association also for recording. Because court has said bylaws.
Registry, so that we have a
When
copy.
we take the documents
No, I
like,
have given a copy. We have given a
we
copy.
will not take any document in the court.
Yes.
We have made a
We have filed
procedure
it
now, please follow that
No, we
procedure.
have filed it in the,
Yes,
even the memo also.
the learned advocate general has placed his arguments. He is continuing with his arguments, put up tomorrow at 2:30.
Please, Your Lordship. Please.
Tomorrow I may be given some 10 minutes time. 1.6. Please. So the 141 section I want to highlight only on that point, or Education Act. Obliged.